Exhibit Z, misconduct for Rise Halfway House violent behavior dated 2/12/2024. Exhibit AA, Rise Halfway House incident report for aggressive behavior incident dated February 12th, 2024. Exhibit BB, misconduct report for unaccountability in the community dated.
Yes, you heard right. She just mentioned Exhibit Z and then AA and then BB. That means that this parole officer had to use so many exhibits, she ran out of the letters in the alphabet. She is up for a parole revocation hearing with so many strikes. We've never seen anything like this before, but she happens to have, I believe, the best public defender in the state of Connecticut representing her. So this is going to be interesting to see. You might be surprised. With that, let's jump in.
Your parole and to determine if you should be held in prison pending further proceedings. The state, not you, has the responsibility to show that there is probable cause to believe you violated one or more of the conditions of your parole. If I do not find probable cause, I will reinstate your parole, which means releasing you and placing you back on parole supervision. If I find probable cause and determine that the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know that at a preliminary hearing, it is an adversarial proceeding, and anything you say at this hearing can be used against you, and this hearing is being recorded. So, Mrs. Huslin, you do have important rights. You have the right to be represented by an attorney at this hearing, which you have exercised here today. You have the right to receive written notice of charges of violation. Did you receive written notice?
Yes.
You also have the right to review the evidence against you before this hearing, as well as you have the right to submit evidence in support of your case. At this hearing, you have the right to call and examine voluntary witnesses and to cross-examine any adverse witnesses. Do you understand these rights?
Yes.
And Attorney Famlighetti, have you had sufficient time to prepare for today's hearing, and are you ready to go forward?
Yes, I spoke with her on 2 occasions. I am prepared to go forward, and it looks as though she has paperwork in front of her, so I am not sure if Ms. Huslin wishes to speak after I speak.
What I can do is I can go ahead and just
Go forward.
I'll swear her in, as well as Officer Sheehan. If you could both please raise your right hand.
Me?
Yep.
If you wish to testify later.
Yes.
All right. So do you solemnly swear or solemnly and sincerely affirm, as the case may be, that the evidence you shall give concerning this case shall be the truth, the whole truth, and nothing but the truth, so help you God, or upon penalty of perjury?
Yes.
And Officer Sheehan?
I do.
Thank you. All right. So what we're going to do is we're going to review the charges that Parole and Community Service is bringing against Ms. Huslin and the information underlying each charge. Officer Sheehan, you have the parole violation notice in front of you?
I do.
All right. So if we can start with charge 1 under release direction specific to reporting.
Sure. On 2/15/2024, you had lied to Halfway House staff and parole officer about being enrolled in adult education classes after speaking with Lois from Hartford Adult Education and Catherine from Stanford Adult Education. You were not enrolled in classes from January 25th, 2024 through February 8th, 2024, but you requested community passes for classes that you were not enrolled in, went to the library to complete assignments even though you did not have assignments, and continued to tell Halfway House staff that you needed to go to the library to complete assignments on January 26th, January 30th, February 1st, February 2nd, February 3rd, February 5th, February 6th, and February 7th. This is a violation of parole condition release direction. You will follow the parole officer's instructions and report as directed to parole officer. On
Charge number 2. Yeah. Charge number 2 under curfew.
On December 8th.
Her offense list is so long that I'm going to put this on 4x speed. It actually goes through the letter Z and then back to A, so the AA, BB, CC, and DD. It's too long to go, so we're going to 4x. I'll see you at the end of this.
And charge number 3 under drug testing.
On 8/21/2023, or about that date, you used cocaine and PCP and rendered a positive urine for cocaine and PCP. Based on your actions, this is a violation of sexual condition as registered officer. On 8/30/2023, or about that date, you used cocaine and PCP and rendered a positive urine for cocaine and PCP. This is a violation of sexual condition as you will follow the law of as registered officer. On 10/2/2023, or about that date, you used cocaine and rendered a positive urine for cocaine. This is a sexual violation of discretion. You will follow the law of as registered officer. On 10/14/2023, or about that date, you used cocaine and rendered a positive urine for cocaine. This is a violation of sexual condition discretion. You will follow the law of as registered officer. Charge number 4 under drug testing. On 9/16/2023, you found smoking and have a vape pen in your room. You touched the item of staff. This is a violation of House Handbook. Rule page 8, smoking is not allowed anywhere permitted. Access to grounds for the purpose of smoking is not permitted unless staff calls it. On 9/17/2023, you found smoking and have a vape pen in your room. This is a violation of House Handbook. Rule page 8, smoking is not allowed anywhere permitted. Access to grounds for the purpose of smoking is not permitted unless staff calls it. Staff will be staff while leaving staff, staff, and staff and corner staff in office. You will not that policy did not execute behavior 1 to staff call the manager and rule officers. This is a violation of House Handbook. Rule 90 days removal other staff their rights. On 7/2023, you were not aggressively for staff, you were not aggressive manner while leaving or touching yourself in the hand with staff in office. You were not office and you don't get staff. This is a violation of House Handbook. Staff will not use on 1/3/24, you did this on the House on 12/3/24. This altercation is in your house and this is a violation of House. This is a violation of House Handbook. And 3/2 you were not following the on 1/2 you're not following instructions. Not your how you run the staff. This is a violation of House Handbook. This is a violation of House Handbook. And 3/2 rule of altercation of other staff their rights. Right after the staff rule officers and staff to come together. On 2/12/24, you were exhibiting investigator for the staff. You were getting you were getting on your face and recording your face. This is a violation of House Handbook. This is a violation of House Handbook. And 3/2 and not engaging in altercation of other staff their rights. On 2/13/24, you were following these. You were getting on staff. This is a violation of House Handbook. Rule page 8. So this is you were requesting classes for classes that were not holding. When I was staff, you staff, and the staff, you used staff, based on January 26th, January 30th, February 2nd, February 6th, and February 7th. These days noted, you were leading to the
And you can please put on record evidence.
Exhibit A is signed to the understanding of the 8/3/23 was signed on January 5th, 2024. Exhibit B, record of order. Exhibit C, notice of approval violation. Exhibit D, rule violation report. Exhibit E, notice of rights. Exhibit F, access to rights. Exhibit G, rise program. Exhibit H, civil access report. Exhibit 8/21/23. And the results 8/21/23. Exhibit J, arbitration of test 8/23. Exhibit K, civil access report. Exhibit House and 9/16/23. Exhibit L, civil report access report. Exhibit 17/23. Exhibit N, report 7/23. Exhibit N, civil access results 10/2/23. Exhibit 0, civil report 8/23. Exhibit P, civil access incident report 11/16/23. Exhibit 12/23. Exhibit R, civil access report incident report 2024. Exhibit U, civil house access incident report positive. Your analysis 1924. Exhibit D, misconduct from Rise Access Policy 1/22/24. Exhibit W, Rise Access incident report 1/22/24. Exhibit X, community passes for library Sunday time dated January 23rd, January 26th, January 6th. Exhibit Y, Rise Halfway House Program Incident Report for having a vape in her room, dated 2/12/2024. Exhibit Z, misconduct for Rise Halfway House violent behavior, dated 2/12/2024. Exhibit AA, Rise Halfway House Incident Report for aggressive behavior incident, dated February 12th, 2024. Exhibit BB, misconduct report for unaccountability in the community, dated 2/19/2024. Exhibit CC, Rise Halfway House Program Incident Report, witness refusal to be placed on GPS, dated 2/15/2024. Exhibit DD, video submission of 2/12/2024 incident at Rise Halfway House. Exhibit EE, photograph of cigarette lighter.
Thank you very much. Take a sip of water.
Thank you so much.
Okay, so in regards to charge number 1, I'm going to be making a no finding. I'm not going to need to take any information regarding that charge. Charge number 2, I'm going to make a no finding. I'm not going to be taking any testimony in regards to that, as well as charge 3. All 3 of those are not going to be considered during today's hearings. So we're going to focus on charge number 4. Officer Sheehan, you do have the opportunity to provide any further information at this time in regards to this charge. Would you like to make a comment at this time? Or it's actually multiple for charge 4, but.
Yeah, I put together in the narrative that I'm very concerned about her aggressive behavior. That's my main concern. She doesn't take responsibility for things, and when she's confronted with them, she's she just exhibits aggressive behavior. She's exhibiting aggressive behavior towards offenders, halfway house staff, and myself and another parole officer. It's the behavior of her just not being able to speak. You know, you're not able to guide her to speak. She's constantly speaking over, very aggressive. That's my biggest concern with her. That there's a lot in the narrative. I don't know if you'd like me to read it. The narrative also includes a lot of the stuff that, you know, you've already had a no finding on.
No, so I've already read the narrative, and I apologize. The reason for the no finding on the reporting was because it's charged under the wrong charge, and it doesn't meet the elements of the condition. The same for 2 and 3, curfew. It's the wrong charge. The elements weren't met. Where for that, and the drug testing. So if that was charged under drugs, obey all laws, drugs, it probably might have been a different outcome, but because it was charged under drug testing, it didn't meet the elements there. I did read the violation report, the summary. I did read that. So this part is just specifically to the charges. For the halfway house violation charges that you have against her. So the specific dates, if you have anything in particular regarding those charges.
No, I think that they could speak for themselves.
Okay. Attorney Famighetti.
Yes, so the remaining charges, charge 4. I broke that down into 11 separate parts. I don't know what you broke it down to. I had A through K.
11.
Okay, so I'm going to address them as such. Should I use numbers or letters?
I use numbers.
No.
You use it any way you want. I am
Okay.
flexible.
So I have no comment as to numbers 1, 2, 3, 4, 5. I don't know under 6 whether or not having an unclean room or food in your room rises to the level of violating her halfway house placement agreement. I think that's just a matter of opinion. As to 1 moment, 2, 3, 7, the allegation that she had the gun-shaped lighter, my client adamantly denies ever having possession of that lighter. She actually was a victim of gun violence earlier in her life, so she would never possess something such as that. It's her claim that another resident actually was in possession, and that's someone else's gun-shaped lighter. And so you would think when she was found smoking in 1, 2, having 3 vape pens in her rooms later, you would think that would also be there if that in fact was her lighter. I think it's inconsistent, and I don't think there's probable cause to believe dominion and control over the gun-shaped lighter exists. Then lastly, as to K, her refusal to wear the GPS anklet, I don't have probable cause or an argument to say that she did wear the anklet. However, on the 29th of February, this Thursday, I received an email from Catherine Terscani, the Assistant Director of Stanford Adult Ed and Continuing Education. And she stated that Alecia may have worked with her Hartford advisor from 1/26 to 2/1 when she began working with our NEDB advisor beyond the login date in the system that I provided above. There was a system activity and the student logged in on 1/25 and 1/26, which were dates in question, on course modules previously assigned by Hartford Adult Education for approximately 4 hours. I don't have any information regarding the work she completed, as she may have been still working with her advisor in Hartford. So I think that what my client may not have been enrolled in classes at that period of time, but all parties concur and agree that she transferred from Hartford to Stamford. And in that time, what we say is she was working at the library on the work that she still had to complete and contacting her advisor in Stamford and Hartford, trying to coordinate completing work and then signing up for new work. The student worked at the cultural literacy modules assigned by advisor on 212. She worked on the previous civic literacy participation assignment on 2.8. On 2.8, this advisor assigned the cultural literacy plagiarism model. Once the paperwork was completed and returned, they made contact with the client. So I think there's inconsistent evidence, and this is what I would have argued regarding charge 1, but I'm just giving this information as an explanation as to why my client was so upset that she was being asked to put on a bracelet for classes and courses that she was continuing to do work on. Obviously, should she have put the bracelet on, contacted us, and made those arguments afterward? I spoke with her about that. That would have been the better course of action. But she was continuously frustrated because she was going to the library, doing work, and they continued to call her a liar, which she took personally. Thank you. As to the seriousness of the allegations, I'm sorry.
Hold on. Hold on.
Okay.
You're jumping ahead.
Okay.
Oh, no, it's a prelim.
It's a prelim.
You're not.
Okay.
You're not
As to
jumping
this-
ahead. Go ahead.
As to the seriousness of allegations, we're left with charge 4. I don't think smoking I know there's a number of things, 11 things that they're arguing that she did as a basis of them remanding her. They didn't decide to remand her until she refused to wear the bracelet. Much of this conduct, the positive hearings, which are in there, are from August. We're talking about the whole course of conduct. My client's been incarcerated now since February 15th. Does she need an attitude adjustment, it seems? Is that a reason to go forward with a revocation proceeding? I would argue no. I don't believe these allegations, as they stand, the charges as they remain, are sufficiently serious enough to go forward with further incarceration, that she be held during the pendency of a revocation hearing, and I ask that she be replaced back in a halfway house. Thank you very much for your time and consideration.
Thank you.
You're welcome.
Okay. So as I stated earlier, charge 1 is a no finding, charge 2 is a no finding, charge 3 is a no finding. Charge 4, as I stated earlier, I did break this up into multiple portions. So I'm going to go by each paragraph and each date. So for the 9/16/2023 charge, I'm going to make a no finding on that, as I was not provided with a signed agreement, halfway house agreement, stating that she was informed of that rule. Same thing goes for charge number 2, not charge number 2, but Section 2, which is the 9/17/23 for smoking. Section 3/11/16, where she was acting aggressive, although she should know that she shouldn't be aggressive. I do not have the signed agreement until January 5th, so that is a no finding. December 5th date is going to be a no finding, same reason. January 3rd, the reason for this is it was virtually impossible to happen, as it is dated that she assaulted another client at the Silliman House on December 31st, 2024. Because it states that, although I know Officer Sheehan did mean 2023, I have to look at what's actually presented. So that is a no finding on that as well. Charge 6, I believe, January 22nd. I do not have anything showing that food is not allowed in the house. And in addition to that, the misconduct that was provided did state for January 21st, not January 22nd. So that's going to be another no finding. February 8th, I do not have anything stating that she's not allowed a lighter. Now, is it smart to be carrying around a handgun or a lighter that looks like a handgun? Absolutely not, but it is a no finding there. Am I on 8?
Yes, 2/12/24, I believe.
8 for 2/12/2024, that did have video evidence as well as incident reports. I am going to make a finding on that one, as the evidence did provide verification. Charge number 9, again, the information that was provided me with the wrong date. It was for a different date, so that's going to be a no finding. Charge 10, the evidence that was provided showed me that she had an actual pass that was provided by the halfway house. Whether or not that was provided under false pretenses or not, she had that. I do not have anything showing that she went anywhere other than the library. There was no evidence to show that she was in a different part of the state or anything like that. So that is going to be a no finding as well. And then charge portion 11 on that for the remand, where her language and her refusal to be placed on GPS. I am going to make a finding on that. And due to those actions, I am going to find that the act is serious enough to warrant a revocation. I've also determined that Ms. Huslin should be detained while she waits for her revocation hearing. And at that revocation hearing, hearing examiner will determine if she violated the conditions of her parole. And if so, the hearing examiner will make a recommendation regarding whether the parole should be revoked and what, if any, sanctions should be imposed. That is going to be scheduled tentatively for April 9th.
Okay.
And I think that should be all. And
Correct.
that should conclude the preliminary hearing for Alecia Huslin, inmate number 317044. Is there any questions?
No,
Okay.
don't have any questions. Ms. Huslin, the findings were made only as to not wearing the bracelet that we talked about, okay? And another incident, okay, that there was video that I reviewed, okay, that I'm not making an argument against because of the video I reviewed, that I found that there's probable cause in there. So I'm not making an argument because there is a basis in that. So the hearing examiner has found that there is a basis to go just on those two those two elements of section 4. There is a basis to go forward with a revocation. And so that will tentatively probably happen on April 9th. So I will contact you between now and April 9th, as will Ms. Lopes, our social worker, to talk about what we'll argue at the next hearing, okay?
Okay, so you're saying that you're not going to argue about the incident with the video at all?
No, because all they have to find is that if what on the video happened, and I reviewed the video, whether or not there's probable cause to believe that there was an argument and that you acted in the way they said you did, which I watched, and I believe that there's a basis for them to go forward to the revocation proceeding. So no, I'm not making an argument based upon what I reviewed in the video. The video was very clear that there was an argument, and the video was very clear that both parties were waving their arms around and poking at each other. And that's all they have to show.
Right.
Thank
Okay.
you.
You're
All right,
welcome.
so I will be in touch with you.
And it's April 9th?
Well, that's tentative. In other words, that's what they're going to try to schedule it for. But I will be in contact with you between now and then, as will my social worker, to get more information from you to use to try to argue mitigation or why we think you shouldn't be held much longer than that date. Okay?
Thank you kindly.
You're welcome. Thank you for your attention.
You too.
Good luck to you.
Thank you.
Also, thank you.
Okay, so I mean, only in the state of Connecticut, right, where they have a preliminary revocation hearing before they make a finding to have an official revocation hearing, which we're about to watch. And then finally, they have the next board that approves or does not approve that finding in the official revocation hearing. So they have 3 hearings, so to speak, or at least 3 points of contact before they actually make a decision. It's a good use of taxpayer money, right? They also have public defenders, which I will say what you want about him, man. He is good. I mean, you know, it's interesting. And again, it comes to the cultures of seeing the different states, and it's Connecticut, and Connecticut is a state that I think everyone, you know, it's known for Harvard, it's known for Yale and academia, and you see it in this process. I mean, these parole officers are being held at the standard of basically like assistant district attorneys. I mean, did you see how many items was taken off of her list because the parole board member, who is also basically an attorney level, is saying, well, this isn't legal, that's not legal, I can't find findings here, you have the wrong date, you didn't show proof that you brought her the contract. I mean, really? If this was Louisiana, it would never happen. In Louisiana, it's just like all you need to show is that you were involved in criminal activity. You don't need a conviction. You don't need even in a, like, you just need that's the language in Louisiana, involvement in criminal activity. And then they allow the parole board to be as vague as they want with those words. In Connecticut, it's like a court hearing. It's like, whatever, you misspelled her middle name. Can't take that one. I mean, she had so many exhibits, they ran out of letters in the alphabet. They had to go to A, B, B, C, C, D, D is where it ended because there's nothing after Z. I mean, you can't make it up. And then this attorney, with the help of the parole officer, gets it knocked down to what, just 2 things? It was incredible. So we're going to go see if the parole board, what they find. They're only going to have, remember, they're only going to have, I think, 2 findings to work with. All of that other stuff that was thrown out, they can't work with that. So, you know, she might have a fighting chance. We're going to have to see. And then at the end of that, I'll unpack it with some more details that Richard found. But man, it's a whole different breed in Connecticut. And like it or not, I could see where there are upsides. You know, you might say, hey, it's better to give proper representation so we don't have this revolving door of inmates getting revoked. But at the same time, I just wonder. Anyways, let's jump into the next hearing. It's fast forwarding 1 month to the date actually, which is pretty cool. So this was 4/17. We're fast forwarding to 5/17/2024. Let's not make the mistake like the parole officer made and give the wrong date. Okay, with that, let's jump in.
Yes.
So we now review the charges that the state appeal is bringing against you and the information underlying each charge. So at the preliminary hearing, no findings were made on charge 1, reporting, charge 2, curfew, charge 3, drug testing, and on charge 4, parts 1 through 6, as well as 8 and 9. So I'm going to read the only charges that we are considering today, which is charge 4, additional condition, halfway house placement. Part 7, on 12/12/24, you're exhibiting aggressive behavior towards another resident at the Rise Halfway House. You're getting up in her face, reportedly poking her in the face. This is a pattern of behavior that has been reported by Rise Halfway House and Stillman Halfway House staff in the past. This is a violation of Halfway House Agreement number 7. I will treat others with respect and not engage in verbal or physical altercations with other offenders, staff, or third parties. In part 10, parole officer stated on 2/15/24, parole officers went to Rise Halfway House to place GPS on you for curfew violations unaccountable in the community. You refused to have parole officers place you on the bracelet. Parole officers continue to instruct you to place the GPS bracelet on, and you refused over 3 times, saying you're not putting that on me. Fuck that. Call your supervisor. I'm not putting that on. I'll leave here. I'm not putting that on. You continuously raise your voice using profanity, refuse to allow parole officers to speak. This aggressive behavior resulted in your remand back to custody. This is a violation of Halfway House Agreement. I will treat others with respect and not engage in physical or verbal altercations with other offenders, staff, or third parties. And the state is following exhibits that are pre-marked for identification purposes as Exhibit A, signed statement of understanding and agreement, conditions of parole. B, Connecticut Board of Parole remand to custody order. C, notice of parole violation. D, parole violation report. E, notice of parole rights. F, Halfway House Agreement, Rise Halfway House. G, Rise Women's Program Residential Handbook. H, Stillman Halfway House Incident Report. I, Stillman Halfway House Abbott Lab Results. J, offender, voluntary admission for positive substance. K, disciplinary action report for smoking, having a vape. L, disciplinary action report, smoking, having a vape. M, misconduct report, 9/27/22. N, Stillman Halfway House Lab Results. O, misconduct report dated 10/14/23. P, Stillman Halfway House Incident, 11/16/23. Q, Stillman Halfway House Incident Report, 12/5/23. R, Stillman Halfway House Incident Report for unaccountable in the community. S, Stillman Halfway House Incident Report, physical threats of violence, dated 1/1/24. T, misconduct or threatening behavior, dated 1/8/24. U, Stillman Halfway House Incident Report for positive analysis. B, misconduct for Rise Halfway House for instructions not following. W, Rise Halfway House Incident Report for not following house rules. X, community passes for the library study time. Y, Rise Halfway House Incident Report for having a vape. Z is misconduct from Rise for violent behavior, dated 2/12/24. Exhibit AA, Rise Halfway House Incident Report for aggressive behavior. BB is misconduct report for unaccountable in the community. CC, Rise Halfway House Program Incident Report. Witness refusal to be placed on GPS, 2/15/24. Double D is video submission on 2/12/24 incident at Rise Halfway House. And double E is photograph of cigarette there. Did you receive notice of parole violation report, and other documents I marked, and did you review them?
Yes.
Okay. And council saw the following exhibit pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. And I received Exhibit 2 and 3, which are letters of support that were received. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Okay. We have no witnesses, so now defense's opportunity. If you'd like to speak to any of the evidence at this time. You're muted. Oh, you're still muted. I can't hear you.
There are no findings as to the first 3, as you stated earlier. However, as to charge 4, only 2 findings were made. As to the first of those 2 findings from 2/12/24, I don't think it amounts to the violation of her condition. This is just an incident. Although on video, it appears as though both parties were engaged in some sort of conversation. I don't think it rises to the level of a violation. I don't believe that it meets the preponderance standard as to violating a condition here. I honestly don't believe that it violated the condition. Didn't see any statement or testimony from the other party involved. My client was merely standing up for herself in something that she believed was instigated by the other party, and no comment as to the last. We made an argument in our preliminary hearing that the reason why she refused to wear the GPS bracelet is because she believed that she was being erroneously charged with not enrolling in classes, and that's why she went to the library. There was no finding made as to there. Understandably, she may have gone about it the wrong way. She should have worn the bracelet, then contacted an attorney or contacted us and said, tried to prove or show the proof that she had, in fact, been going to classes. And so those are our arguments regarding the preponderance standard.
Thank you.
You're welcome.
All right, so what I'm going to do next is I'm going to announce my findings. As I said before, I'm only looking at charge 4, those 2 parts. So regarding charge 4, additional board commission halfway house placement, on part, excuse me, it's part 8. I'll make sure. Regarding parts 7 and 10 are the ones I'm looking at. I do find you violated that condition, part 7, which is the date of 2/12, and part 10, which is date of 2/15. That's based on the evidence provided, which is exhibits FZ, AA, and D for part 7, and AF and C on part 10. That includes the fact-finding portion of the hearing. And before you make recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you'd like to at this time.
Yes. So I'd ask that you consider the 2 letters of support regarding the changes that the parties had seen in my client over the course of the years, particularly recently regarding her efforts at education and her effort to improve and better herself. My client is a single 38-year-old woman. She receives significant familial support from her mother, aunts, cousins. Her father resides in Florida. However, she has never met him. She has been working in the community and receives significant support from her ABH worker, Christy, and also from Ms. Tracy Shoemaker and Edward Andrews of the Second Chance Reentry Initiative program, where she's receiving education, and also through her church community. My client is the mother of 4 children, and her eldest adult child is expecting her first grandchild, and she's very eager to get out and be there for her 21-year-old daughter as she's expecting recently, within the near future. My client's been employed at Goodwill in the past, as well as attending school 2 days a week at the same time. She's been a part-time cashier at Dunkin' Donuts in Manchester, a seasonal handler at UPS. Then she worked full-time at Goodwill in Hamden. She had been working at a gas station at night in Branford, Connecticut. So she has an excellent work history. She was completed a women's group through Community Partners Action. She's participating and receiving education in both Hartford and Stanford offices, doing the Ascend program through SCRIP, Second Chance Reentry program. She's also in a trauma-based program, and she's also participated in individual therapy. She's on medication management. She received the Moz Daily Treatment Clinic, and also was working with the Connecticut Community for Addiction Recovery, CCAR. She received primary services through Yale.
Are you muted?
Sorry, I put my paper on my computer and it turned off. She's in a group at York Correctional called SSS, Sisters Standing Strong, and she meets 3 times a week. She wishes upon reinstatement to be replaced or placed at the Silman House in Hartford on Retreat Avenue. She also in the future would like to explore 2 other sponsors, but she wishes to be placed at the Silliman House. School is her #1 priority. She wishes to obtain her high school diploma and return to the diploma program and APD. She aspires to study business, go into the clothing design, hairdressing, and house cleaning business. She also enjoys teaching and writing, and has written a children's book named Junior's Bedtime, which she hopes to publish. As I stated earlier, it takes 2 to tango. I believe that this was just a verbal argument, not even an argument with this other person. That's one basis of the violation, and the other basis was her unfortunate decision, and she was emotional, unfortunately, to refuse to wear the bracelet. She's been incarcerated now 2 months. I believe this was 6 months into her parole, so she had done well for 6 months. And we believe that she should be released hopefully as soon as possible. We're asking for the 25th date of April. We don't believe that these 2 small allegations of halfway house placement are significantly serious enough to warrant further incarceration. She understands the errors of her ways, and she has a lot to look forward to. The letters of support said that her behavior, her focus has been on education, and she is really dedicated to her schooling and hopes that she can do more for her children. Thank you for your time and consideration.
Thank you.
You're welcome.
All right, so I have listened to all the testimony today. I will put on the record that you do have a prior violation for absconding, as well as received 7 misconducts on this term of supervision. And you were out in the community for approximately 6 months before returning. We'll note that the PCS, your officer, did recommend anger management programming as well as halfway house placement. I do take into account that I did make no findings on some of the charges that were brought up. So taking into consideration all of those things, I am going to recommend, 1 second. That parole be revoked to be re-paroled for June 14th of 2024. It's about a 4-month period combined as a sanction. Recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation, behavior management program for anger management, a general no contact with DM without PO's permission, and no contact with victim LH. My findings will go to the parole board on April 25th. The board's going to make the decision. So they can lessen it, they can keep it, or they can make it longer. So if they want a longer sanction, you'd be notified of the reason why, and you'd have a supplemental hearing if it got to that point. Do you have any questions about anything that was said? Ms. Housen?
You said you're setting a date for me to be released on June 14th.
That's a recommendation. So the parole board's going to make the decision April 25th.
Will I be present on the 25th?
No,
Okay.
just call me the afternoon of the 25th or the next day, and I'll let you know what the board decided. Okay, miss?
Yep. Thank you.
Thank you.
All right, you're all set for today.
Thank you.
Wish you best of luck.
Thank you.
Okay, so the bottom line is that after she gets revoked for the whole ABCs and plus some, after she has her preliminary hearing, after she has her parole hearing, yes, finally the board made their decision and they agreed with it. A sanction up until June 14th. So at the time of this recording, she's got less than a month left to serve, and she's only had a sanction of what? A handful of months. All that cost, the attorneys and the caseworkers and the parole officers, and it's like all of this for what? And when you take a step back, it's like, wow, what a waste. The whole thing is just such a waste. And I don't know what the answer is, but come on. I mean, but I guess when you go through the legal process, right, and you throw away basically like A through double B, you're left with just a couple things. What are you supposed to do? It doesn't look like that big of a deal anymore. But the bottom line is, before you throw that stuff away, it's just, she's refusing to wear a GPS. She's disappearing. She's poking the staff in the face. She's doing all of this stuff. And it's like, what? And what's her record? I mean, her parole date, thank you, Richard, for the information. Her special parole ends 2026. Not that much more time. She just needs to get through a couple of years, right? And there's some more information Richard shared. There is, remember at the beginning they spoke about that weapon where she had violence in it. So there's a whole case law where she went through a traumatic incident that Richard shared, but I don't know if we go through it now. It is pretty intense though. But you got to give this attorney credit how he knew that and like how he impresses me every time. We've seen him cover roaches, and man, I got my first impression of him ever seeing him was covering the worst of the roaches, defending them. And I was like, how do you do that, man? But he's just so passionate about, you could tell he puts in the work. You could tell he actually does his homework, and his mind. I'm amazed by his mind because I think everything just clicks for him. He gets it. I don't know how many hours I'm just speculating, and it puts into these cases, or if he just sees it and he just knows, like a chess player. They see a board and they know everything what's going on. It's not that. And I just wish we could convert him to being, maybe a prosecutor for us or something. And it also makes me wonder why doesn't set up a practice. I mean, he's clearly good at his job. I left to, maybe he would want to get interviewed, but he seems like he has a personality. Maybe he, I've emailed a few people for interviews and I haven't gotten responses. I'd be curious to interview him. So, yeah, here's one thing that Richard shared on this case. So this is in 2014. Maybe this is one of her big charges that she's locked up for. A city woman was charged with leaving the scene of an accident and possession of a powerful hallucinogen after she crashed her minivan into, and she's doing PCP, right? Like, that's just a drug you don't want to do, man. PCP. Out of all things you can pick, PCP. After she crashed her minivan into a condominium in the Old Southern Village complex. She was charged with leaving the scene of the accident, failure to drive in proper lane, possession of hallucinogen, and I'm guessing it's PCP, sale of certain illegal narcotics, possession of controlled substance within 1,500 feet of public housing. I didn't know that's a law. Okay. And interfering with police. Maybe that's a Connecticut thing. Like, I thought they was going to say 1,500 feet with the school. No, public housing. Like, that's basically setting, it's like, we're going to make a law. You can't have an illegal substance within 1,500 feet of where everyone lives. It's like, is that really going to stop them? Or is it just going to throw on more charges? It's so weird. So people think they're so brilliant making these laws, and it's just all a show, right? It's just like, so like, I'm gonna pass this, and then I'm gonna make a press release about it. Yeah, it's really gonna help. She was arraigned in the State Superior Court in Stamford on Friday afternoon, where Judge Thomas set the bond for $25,000. Captain Richard Conklin said police were called at 1:05 a.m. on a report of someone crashing a 2007 Chevy van into an occupied condominium at 15 blah, blah, blah. No injuries were reported. Witnesses said they saw the driver and a passenger get out of the car and begin walking away. Police who found them and a man walking together on a nearby, calmly walking away, no big deal. Then, because they fit the description, the two leaving the accident, he said police saw the two had scrapes and bruises. Special Assistant Attorney Sarah Ross said at her arraignment that Houseland and her friend admitted to being in the car when it hit the home. As she was being taken into custody, police searched and found in the backpack 14 bags of PCP worth $300. This is a very potent hallucinogen that most people have difficult walking when they are using it, and certainly shouldn't operate a vehicle, as this incident illustrates, said the police officer. Thank you for your service, soldier. Anyways, it might have been the PCP, but it also could have been the water. Like I said, if you're traveling through Connecticut, buy the bottled water. I don't want to see you at one of these parole revocation hearings. Thank you, Richard, for the info. And with that, I'll let you go.